brief of Ekene O Madugwana.
So is Glorious D. Ofe
Yes, my lord.
holding the brief of what? Of who?
Ekene O Madugwana. He has been the counsel.
That's
Yes.
E.O.
Yes.
Madwa
Guana.
Gwana for the claimant.
Yes, my lord.
This is my short judgment. Thank you. So the claimant commenced this suit by a complaint and other accompanying processes filed on the 19th of June 2019 and asked for the following reliefs as contained in the statement of facts against the defendant. Number one, a declaration that the claimant is entitled to all his accrued salaries, emolument, allowances, pension, and other entitlements from April 2017 to September 2017, when the employment constructively came to an end. Number two, an order of this honorable court directing the defendant to pay the claimant his accrued and unpaid salaries, emolument, allowances, pension, and other allowances from April 2017 to September 2017. Number three, an order that the sum of 1.7 million naira being the total sum of the claimant outstanding and unpaid salaries from April 2017 to September 2017 be paid to the claimant. Number four, an order that the sum of 144,000 naira being the total sum outstanding and unpaid on the claimant's pension scheme from June 2016 to September 2016 before his salary increase be paid to the claimant. Number five, an order that the sum of 720,000 naira being the total sum outstanding and unpaid on the claimant's pension scheme from October 2016 to September 2016 after his salary increase be paid to the claimant. Number six, an order that the defendant caused the income tax of the claimant and penalty thereof from June 2016 to September 2017 to be paid to the Lagos State Internal Revenue Service. Number seven, 10 million naira as punitive and exemplary damages against the defendant for constitutional termination of the claimant's employment. Number eight, the sum of 5 million naira as general damages against the defendant. Number nine, prejudgment interest on the claimant's outstanding and unpaid salaries from April 2017 to September 2017 at the rate of 21% per annum, and a post-judgment interest of 20% per annum on the judgment sum from the date the judgment is given until judgment is finally liquidated. But then cost of 1 million naira, cost of the action in the sum of 1 million naira. Upon being served with the originating processes, the defendant did not enter any appearance nor file any statement of defense. From the pleading filed by the claimant, his case is that he was employed by the defendant via a letter of employment dated 13 June 2016 and was placed on a monthly salary of 180,000 naira, which was further reviewed to 300,000 naira monthly via a letter dated October 2016. Claimant stated that even though the defendant did not issue him pay slips, but the payment of his salary was made via bank transfers. According to the claimant, while he's been owed outstanding salaries, but he was still reporting to duty plying a hazardous and expensive road and had to source for additional funds to take care of the expenses that accrued on his obligations to his job. It was also about that he had a valid employment with the defendant and carried out his job within the contractual terms of his employment for the duration which the employment subsisted, but was not remunerated for 6 months. It was alleged that the employment of the claimant was constructively terminated through non-payment of salary. The defendant did not file any defense but cross-examined the claimant. At the trial, which commenced on 28th of September 2021, the claimant testified by adopting a statement on oath dated 19th June 2019 and tendered the following documents as exhibits. Exhibit CN1, CN2, CN3, CN4, 5, 6, C, and CN7. The claimant was thereafter cross-examined by learned counsel to the defendant, and as there was no cross-examination, the case of the claimant was then closed and the matter was adjourned for adoption of final written addresses. Sorry. The claimant was thereafter cross-examined by learned counsel to the defendant, and as there was no re-examination, the case of the claimant was then closed and the matter was adjourned for adoption of final written addresses. Claimant filed his final written address and adopted same on 28th of February 2022, and the matter was then adjourned to 19th May 2022 for judgment. However, before the adjourned date for judgment, the defendant filed their final written address alongside a motion to regularize same. Claimant also filed his reply to the points on points of law to the defendant's final written address. Final written address of the claimant. The claimant's final written address. Let me skip this one. The final written address of the claimant. Let me skip it. Then final written address of the defendant. Let me also skip it. Then claimant's reply on points of law. Let me also skip it and go to my opinion. I've carefully considered the pleading and the evidence as presented by the claimant. I've also read the submissions of the learned counsel for the parties, and the issue to resolve is whether from the evidence adduced by the claimant before this court is entitled to the relief sought. The grounds of the claimant is that he was employed by the defendant via a letter of employment dated 13 June 2016 and was placed on a monthly salary of 180,000 naira, which was further reviewed to 300,000 naira monthly. That even though the defendant did not issue him any pay slip, but the payment of his salary was made via bank transfers. According to the claimant, while he's been owed outstanding salaries, he was still reporting to duty and had to source for additional funds to take care of the expenses that accrued on his obligation to his job. It was also about that he carried out his job within the contractual terms of his employment for the duration which the employment subsisted, but was not remunerated for 6 months. It was alleged that the employment of the claimant was constructively terminated through non-payment of salary. As it was earlier stated, the defendant, upon being served with the initiating processes, did not enter appearance nor file any defense, hence the suit appears undefended. However, the law remains settled that whoever desires any court to give judgment as to any legal right or liability dependent on the existence of any fact which he asserts shall prove that those facts exist. Equally, when a person is obliged to prove the existence of any fact, it is said that the burden of proof lies on that person. The claimant's claim is basically for entitlements, and in law, claims for entitlement being monetary claims are a claim for special damages. And the burden thus lies on the claimant to prove his specific claims. In other words, it is the duty of the claimant who asserts the existence of any legal right to prove that those facts exist. See the case of BP Industry Limited and Coca Industry Limited. It is tried that where evidence given by a party to any proceeding was not challenged or controverted by the opposite party who had the opportunity to do so, it is always open to the court seat of the proceedings to act on the said unchallenged evidence before it. See the case of Odulaja and Haddad. See also the case of Ogonya and Nikon Insurance PLC. Contrary to the contention of the defendant, it can be seen from exhibit CN1 and CN2 that the claimant was an employee of the first defendant. Exhibit CN3 also shows that the claimant's salary was paid by both the defendant until March 2017 when the defendant ceased paying the claimant even though he kept working. Similarly, exhibit 1 also shows that the claimant was placed on a monthly salary of 180,000 naira, which was further reviewed to 200,000 naira monthly. See exhibit CN3. I wish to also observe that the second defendant signed the claimant employment letter, paid his first salary from her personal account into exhibit CN3, and continuously issued instructions to him with respect to official assignments and tax, while subsequent salaries were paid to the claimant from the first defendant's account into exhibit CN3 until March 2017 when the claimant began to experience less salaries at the instance of the defendants, which eventually led to his construction dismissal. Upon a careful perusal of exhibit CN3, I observed at page 5 of the said exhibit that on 8th of July 2016, the second defendant transferred the sum of 190,000 naira being the claimant first salary into his account. That on the 8th and 9th of August 2016, at page 8 of exhibit 3, the first defendant also transferred the sum of 100,000 naira and 80,000 naira respectively as the claimant's second salary into his account. Page 12 of exhibit C3 also shows that the first defendant transferred the sum of 180,000 naira as salary on the 6th of September 2016. Now, on the 6th of October 2016, the first defendant similarly transferred the sum of 180,000 naira as seen at page 14 of exhibit CN3. Added to the above, the claimant's salary was increased to 300,000 naira, and on the 7th of November 2016, the sum of 300,000 naira was credited to the claimant as his October 2016 salary. See page 18 of exhibit CN3. At page 24 of exhibit CN3, the sum of 300,000 naira was also credited to the claimant for his November salary, 2016 salary. On the 16th of January 2017, the sum of 300,000 naira was also credited by the first defendant as salary for the month of December to the claimant. This is also shown at page 31 of exhibit CN3. On the 16th of February 2017, at page 34 of exhibit CN3, on 6th of March 2017, and 6th of April 2017, the sum of 300,000 naira each was credited by the first defendant as salary for the month of January, February, and March 2017 to the claimant. It can further be observed that from April 2017 to October 2017, the defendant did not pay the claimant any salary. The total sum of 1.7 million naira remain outstanding and unpaid salaries of the claimant. In a master and servant relationship, it is part of the duty of the employee to be willing and ready to discharge his responsibilities under the contract. He must be able, willing, and ready and present himself physically for same. The employer, on the other hand, has a corresponding duty to, among other things, allow an employee an ample opportunity and make the environment conducive to discharge his duties and responsibilities, where therefore the employee is willing and able, but the employee's conduct becomes both unbearable and intolerable for the employee to discharge his duty, where the employee is not afforded opportunity and space to discharge his duty under the contract of employment, then such is considered as constructive termination, which is often referred to as constructive dismissal. It was pointed out in Danjidda, CYF, and Barat that a contract of employment could be terminated by one party without the other party actually being aware of the termination. One of such instances is a situation of a constructive termination, as in the instant case. Lord Denny MR made an exposition of the position of the law in Western Excavating ECC Limited and Sharp. Thus, and I quote, if the employer is guilty of conduct which is a significant breach going to the root of the contract of employment, or which shows that the employer no longer intends to be bound by one or more of the essential part of the contract, then the employee is entitled to treat himself as discharged from any further performance. If he does so, then he terminates the contract by reason of the employee's conduct. He is constructively dismissed. The employee is entitled in those circumstances to leave at the instance without giving any notice at all, or alternatively, he may give notice and say he's leaving at the end of the notice. But the conduct must in either case be sufficiently serious to entitle him to leave at once, unquote. In the instance case, it was stated by the claimant in paragraphs 29, 30, 31, and 32 of the statement of facts as follows. I will also skip that. It appears from the above that this case is an appropriate one for the application of the doctrine of constructive termination. And again, by virtue of Section 3 of the Pension Reform Act, the defendant were obligated to remit pension contributions for the claimant at the sum of 144,000 naira, the total sum outstanding and unpaid on the claimant pension scheme from June 2016 to 2016, and the sum of 720,000 naira, the total sum outstanding and unpaid on the claimant pension scheme from October 2016 to September 2016 after a salary increase was not remitted by the defendant. It was also stated that the defendant did not remit the tax component on Exhibit C1 as contracted with the claimant. It was above by the claimant at paragraphs 33 and 34 of the statement of facts as follows. I also skip them. It is the law that where there is no statement of defense or evidence in support of same, then there is no issue joined, and the argument and settlement of fact are deemed admitted. See the case of Emodi and Emodi. In law, fact not expressly denied or evasively denied are deemed admitted. Similarly, it is the long-established rule that facts not disputed need no further proof, and admitted facts are the best evidence against the person admitting same. See the case of Pubari and FRN. Although the claimant evidence remain unchallenged and uncontroverted, should be deemed admitted given that the defendant did not file any statement of defense, but this does not absolve the claimant from proving his case under the minimal evidence rule. See the case of Lamy and Data Processing Maintenance Services Limited. It's clear from the pleading and the testimony of CW1, as well as the content of the exhibit presented, that the defendant has actually no defense to the claimant's claim. Therefore, the argument of the claimant, that his outstanding salaries and emoluments have not been paid, remain unchallenged and uncontroverted, and the court ought to act on stem and grant the relief sought relating to those arguments, and I so order. On this score, therefore, claimant's reliefs 1, 2, 3, 4, 5, 6, and 7 are hereby granted. The claimant is therefore entitled to all his accrued salaries, emolument, allowances, pension, and other entitlements. Part of the interest claim appears to be a prejudgment interest, and the law is that prejudgment interest on a debt or loan can only be awarded where there is sufficient evidence of an agreement, can only be awarded where there is sufficient evidence of an agreement between the parties such that such interest will be paid. The agreement should contain details such as rate of the interest, date of commencement, date due, whether weekly, monthly, yearly, or other specified period. However, there's no such agreement implied placed before the court on the payment of that interest in the event of failure to pay the claimant's salary. See the case of Ekpenyong and Nyong. All said, and for the reasons given above, I'm satisfied that the claimant has been able to prove his case against the defendant. For the avoidance of doubt, it is hereby declared and ordered as follows. Number 1, a declaration that the claimant is entitled to all his accrued salaries, emoluments, allowances, pension, and other entitlements from April 2017 to September 2017, when his employment constructively came to an end. Number 2, an order of this honorable court directing the defendant to pay the claimant his accrued and unpaid salaries, emolument, allowances, pension, and other allowances from April 2017 to September 2017. Number 3, an order that the sum of 1.7 million naira, the total sum of the claimant's outstanding and unpaid salaries, from April 2017 to September 2017 be paid to the claimant. Number 4, an order that a sum of 144,000 naira, being the total sum outstanding and unpaid on the claimant's pension scheme from June 2016 to September 2016 before his salary increase, be paid to the claimant. Number 5, an order that the sum of 720,000 naira, being the total sum outstanding and unpaid on the claimant's pension scheme from October 2016 to September 2016 after his salary increase, be paid to the claimant. Number 6, an order that the defendant caused the income tax of the claimant and the penalties thereof from June 2016 to September 2016 to be paid to the Lagos State Internal Revenue. Cost of 500,000 naira shall be paid by the defendant to the claimant. Judgment sum shall attract 10% interest, post-judgment interest per annum until it's fully liquidated. So that's my judgment.
I'm very grateful, my lord.
Thank you, Glorious. We will send you the certified true copies of the judgment to the Lagos division so that they will give it to you.
I'm grateful, my lord. It's called easy.
Thank you. Baba Sheyi,
Yes, my lord.
let's move to a case, ba.
Yes, sir.
So, Mr. Baba Sheyi, parties absent.
What is the absence, my lord?
Yes, Baba Sheyi Lapite. Eh?
Yes, my lord. Lakbite. Yes, my lord.
Okay, Lapite.
Lakbite is a Yoruba name. Lakbite, an Egba name for that matter.
Lapite for the claimant.
Yes, my lord.
Okay.
My lord, can I kindly permitted to vacate the bar?
Okay, you want to run away? Okay.
The convenience of because.
Okay, thank you. You can leave.
Thank you. Thank you, my lord.
So this is my judgment.
As a places.
The claimant commenced this suit by way of complaint and other accompanying processes filed on 4th February 2014 and asked for the following reliefs as contained in the statement of fact against the defendant. Number 1, an order directing and or mandating the second defendant to render account of all money deducted from the claimant's salary from the 15th of August 1998 to 12th of June 2013 for the purpose of pension contribution and paid the sum total with interest at 18% per annum to the claimant. Number 2, an order directing and or mandating the second defendant to calculate the sum total money from the second defendant as counterpart funding and or contribution to the claimant, any paid to the claimant, the said sum from 15th August 1998 to 12 June 2013 with interest at 18% per annum. Number C, an order directing and or mandating the second defendant to remit to the appropriate authority all sum deducted from the claimant's salary as tax An order directing and or mandating the first and second defendant, eventually and severally, to pay to the claimant the sum of 2 million naira as damages to the claimant for wrongful termination of the claimant and for failing to remit the claimant's pension fund. The defendant in action to the suit entered appearance out of time, filing a motion for extension of time on 8th of November 2016, which was granted on 27th of objection on the same date and filed the statement of defense on 15 October 2019 in penalty of the sum of 98,000 naira and 270,000 naira for filing the defense out of time, which has not been settled. From the pleadings filed by the claimant and testimony, it was August 1998 and confirmed on 7 employment. The second defendant has been deducted from his salary, personal, and the sum of 700 deducted from the claimant's monthly salary as income tax, and the sum of 50 naira deducted from the claimant's salary account every month as claimant contribution to the National Health Insurance. While the second defendant also paid 50 naira monthly for all month transmission to the National Insurance. Claimant about that for no just cause, the first defendant ordered the second defendant to pay off the claimant by a letter dated 12 2013, where the claimant was forced to acknowledge the same under duress or threat. Claimant stated that the payoff was wrongful dismissal and he never resigned from his employment. A second defendant has failed to update him with necessary documents in relation to his contribution. Neither have the defendant remitted all monies deducted from the claimant's salary to the pension trust fund. Claimant further about that, he wrote a letter through his lawyer to the managing director of the trust fund pension, PLC, to the trust fund pension, but he got a reply that his details could not be located. Hence, he should revert to the second defendant for his details. From the defendant's statement of defense, which was not regularized, the second defendant case is that the claimant resigned his employment with the second defendant voluntarily on 12 June 2013. The second defendant also stated that the first defendant does not exist and as such cannot allow the second defendant to pay off the claimant, that the claimant verbally resigned his appointment by demanding for his pay and be remanded for insubordination as second defendant. Second defendant further stated that deductions were made from the claimant's salary account for personal which were duly paid to the Lagos Service and only commenced the National Insurance Trust Fund from July 2011 to the claimant's voluntary nation. By the second defendant, remitted all funding deductions made from all staff, including the claimant, to NSITF, and paid the claimant all his terminal benefits as encapsulated document of 2013. It's also about the employer of the claimant was not wrongfully terminated. This matter was first presided over by Honorable Justice Dele Peters, while the evidence of the claimant was taken. And when his lordship was part, it was assigned to Honorable Justice Asian, and upon his transfer to, the matter was assigned to me, hence it started de novo. Trial before me commenced on 11th November 2021, while the claimant testified by adopting witness statement on order dated 4th February 2015, evidence in seal, and tell the following documents as exhibits. C1, C1A, A124, C12, C13, 4, 5, 6, 7, 8, C19, C10, and C11. Claimant was not cross-examined by the learned counsel to the defendant, and he was discharged, closing the case of the claimant. Second defendant was not in court for his defense, and it was foreclosed, hence adjourning the matter for adoption of final written address. Claimant's final written address. Claimant filed his final written address on the 19th of October 2023, where a sole issue for termination was formulated to, whether by the total evidence and or fact laid by the claimant in this suit claimant is entitled to the relief sought. The National Council for the claimant submitted that parties are bound by the terms embodied in the contract of employment, citing the case of Bedu and E.T. It was also a submission of a counsel that the payoff was termination of employment, which was wrongful. Counsel further submitted that the defendant in Exhibit C5 based the termination on the claimant's resignation, which they have failed to produce. That is the strict law that while a contract is wrongfully terminated, the employer must pay for breach of the contract. See the case of Springbank, PLC, and Babatunde. Counsel contended that by paragraph 4, sub 1 of the letter of confirmation, payee tax and Nigerian Social Insurance Trust Fund shall be deducted from the claimant's salary, which the second defendant did. Counsel argued that evidence not challenged remains credible, which should be relied upon by the trial judge, citing the case of Aleleke and Yanda. I've carefully perused the pleadings filed, the evidence adduced, and the submission of the claimant counsel. The claimant in his submission formulated one issue for determination, which will be the point upon which I will decide the case with some modification. The issue I will address is thus, and I quote, whether by the totality of the evidence before the court, the claimant is entitled to the relief sought. The grounds of the claimant against the defendant, as stated earlier, is that he was employed by the second defendant on 15th August 1998, and the sum of 750,000 naira was usually deducted from his monthly salary as income tax. That the sum of 50 naira was also deducted from the claimant's salary account every month as claimant contribution to the National Insurance Trust Fund, while the second defendant also paid 50 naira monthly for onward transmission to the National Insurance Trust Fund. Claimant about that for no just cause, the first defendant ordered the second defendant to pay off the claimant by a letter dated 12 June 2013. However, the second defendant has failed to update him with necessary documents in relation to his contribution. Neither has it remitted all monies deducted from the claimant's salary to the pension trust fund. The claimant further stated that he wrote a letter through his lawyer to the managing director of the trust fund, Pension PLC, but he got a reply that his details could not be located, hence he should revert to the second defendant for his details. As previously noted, the defendant, after being served with the court processes, only filed an appearance and notice of plenary objection, but failed to regularize their defense, making the suit effectively undefended. Nevertheless, the law is clear that a party seeking a court judgment based on a certain alleged fact must prove that those facts exist. Similarly, the burden of proof rests on the party asserting a fact. It is well established that where a party's evidence remains unchallenged by the opposing party, despite having the opportunity to do so, the court is entitled to rely on such uncontroverted evidence. This principle is supported by the case of Odujaja and Haddad. Despite that, where evidence, for the purpose of clarity, let me quickly refer to clause 4 sub A of Exhibit C1. Payee tax and NSIT will be deducted from a monthly salary in accordance with the provisions of the law or tax laws of the Federal Republic of Nigeria. If you have been contributing toward NSIT, please let us have your official registration number. Exhibit 2C, which is the claimant's payoff, meaning full and final entitlement settlement upon his resignation. There is no documentary evidence to show that the claimant tendered his resignation except Exhibit C1, which shows his signature on the document. Second defendant again stated that the claimant verbally resigned on 12th of June 2013. It is duly noted that the claimant appended his signature and date on Exhibit C2, that is the payoff. By Exhibit 10, the claimant details of contribution could not be located by NSTIF and asked to liaise with his employer as they would have record of remittance made on his behalf for his account to be updated. In paragraph 16A to W of the second dependent system of defense, which was not regularized, the second dependent pleaded all personal tax deductions from the claimant's remuneration, as well as other employees remitted to Lagos State Internal Revenue, which receipts were attached to the settlement return. Deductions of the National Social Insurance Trust Fund were made from that the defendant also said that deductions from social insurance trust fund were made from July 2011 till the claimant voluntary resignation on 12 June 2013. From the foregoing evidence, therefore, there's no doubt that the claimant has been able to prove his case against the defendant. However, it has not been proved that Exhibit 1 was signed by the claimant under duress. Other than from the above, therefore, claimants relief 2 and 3 are hereby granted. Claimant has asked for interest. Claimant has asked for prejudgment interest, but the law is that prejudgment interest on a debt or loan can only be awarded where there is sufficient evidence of an agreement between the parties that such interest will be paid. The agreement should contain details such as rate of interest, date of commencement, and debt due. Following from the above, following from the foregoing, it is ordered to follow. Another direction and or mandating the second defendant render account of all money deducted from the claimant's salary from 15 August 1998 to 12 June 2023 for the purpose of pension contribution and pay the sum total to the claimant. Number B, another direction and or mandating the second defendant to calculate the sum total money from the second defendant counterpart as counterpart funding and or contribution to the claimant, any paid to the claimant, the said sum from 15 August 1998 to 12 June 2013. Number C, another directing and or mandating the second defendant to remit to the appropriate authority all sums deducted from the claimant's salary as tax. Cost of 200,000 naira is awarded to the claimant against the defendant. Babashi, that's my judgment. Yes, Mr. Babashi. Yes. Mr. Abashi, can you hear me? Yes, that's my judgment. Can you hear me well? We will send the copies. Yes, Mr. Abashi. We'll send the copies of the judgment to you, certified true copies. Mr. Abashi.
Yes, sir.
Yes, we shall be sending you the copies of the judgment.
As a company, we shall make sure we
You
get that.
you receive it from the registry there, Lagos registry.
Okay, sir. Okay, sir. Very
Yes,
much
and
grateful, sir.
I thank you so much. And in absence of any other thing, we'll call it a day.
As a company, sir. Very much grateful, sir. May the Lord
Thank
bless
you,
you, sir.
Thank
Okay,
you.
sir. All right.
Bye bye.
Bye, sir.
Okay, thank you.